Officers for districts and counties.
Section 97. Commonwealth's Attorney and Circuit Court Clerk Election Term. In the year 2000, and every 6 years thereafter, there shall be an election in each county for a Circuit Court Clerk, and for a Commonwealth's Attorney, in each Circuit Court District, unless that office be abolished, who shall hold their respective offices for 6 years from the first Monday in January after their election, and until the election and qualification of their successors. Part of the Omnibus Executive Reform and Election Schedule Amendment approved by voters in 1992, provided that elections for all but statewide officers should be held in even-numbered years beginning in the year 2000. Reformers proposed the amendment to simplify elections, which had been conducted every year. This amendment, plus one approved in 1979 that shifted legislative elections to even-numbered years, means that elections will be held in 3 of every 4 years of an election cycle. The Kentucky Court of Appeals has parenthetically stated in cases in the 1920s not directly involving Section 97, that the meaning of that section is that circuit court clerks and Commonwealth's attorneys may hold office after their fixed terms have expired until their elected successors are qualified. Section 98. Compensation of Commonwealth's Attorney. The compensation of the Commonwealth's Attorney shall be by salary and such percentage of fines and forfeitures as may be fixed by law, and such salary shall be uniform in so far as the same shall be paid out of the state treasury, and not to exceed the sum of $500 per annum, but any county may make additional compensation to be paid by said county. Should any percentage of fines and forfeitures be allowed by law, it shall not be paid except upon such proportion of the fines and forfeitures as have been collected and paid into the state treasury, and not until so collected and paid. Until 1890, Commonwealth's attorneys were paid a small annual salary plus a percentage of fines and forfeitures collected and paid to the state treasury. In 1890, the General Assembly substantially increased the annual salaries paid to Commonwealth's attorneys to $2,500 and eliminated their right to receive a percentage of fines and forfeitures collected. The framers of the current Constitution complained that the 1890 statute paid Commonwealth's attorneys too large a salary out of the state treasury and eliminated their incentive to collect fines and forfeitures, and therefore they restored the older method of compensation. Until 1976, Commonwealth's attorneys were paid an annual salary of $500, plus a percentage of fines collected and whatever additional salary was provided by the counties in their districts. Since 1976, Commonwealth's attorneys have been compensated by a salary paid out of the state treasury. Although the amount of the salary substantially exceeds the $500 maximum specified in Section 98, no legal challenge has been made for that reason. The Kentucky Court of Appeals held in Commonwealth v. Davis, 1975, that since by law, Commonwealth's attorneys have statewide duties, they are entitled under Section 246 and a statute passed pursuant to that section to annual salaries of up to $12,000 plus consumer price index adjustments using 1949 as the base year.
Section 99. County officers, justices of the peace, and constables' election term. At the regular election in 1998, and every 4 years thereafter, there shall be elected in each county a judge of the county court, a county court clerk, a county attorney, sheriff, jailer, coroner, surveyor and assessor. And in each justice's district, 1 justice of the peace and 1 constable, who shall enter upon the discharge of the duties of their offices on the first Monday in January after their election, and who shall hold their offices 4 years until the election and qualification of their successors. The Omnibus Executive Reform and Election Schedule Amendment of 1992 changed this section to provide for even-numbered year election of county officers, instead of odd-numbered as the original section specified. An amendment approved by voters in 1984 permitted sheriffs to succeed themselves in office, a right denied them in the original version of this section. The rejected Constitution of 1966 would have eliminated county officials as constitutional officers and thus allowed the General Assembly to abolish the office of surveyor, an archaic position that has virtually no duties to perform in modern times. The legislature might also have abolished the office of constable, another position that some argue is unnecessary. The Special Commission on Constitutional Review of 1987 recommended the deletion of constables, assessors, and surveyors as constitutional officers. the Kentucky Court of Appeals has held that when a person who is elected to the office of Justice of the Peace fails to qualify on or before the first Monday in January succeeding election, the office becomes vacant and he or she cannot thereafter qualify, in Barnett v. Hart, 1902. The court also held that when a Justice of the Peace was elected to that office but failed to qualify, his predecessor, elected 3 years earlier, was not entitled to hold over. Rather, there was a vacancy in the office, which was to be filled by appointment until the next general election, in Olmsted v. Augustus, 1901. The Attorney General has ruled that while there is neither statutory nor constitutional incompatibility between the offices of Deputy Sheriff and Deputy Coroner, there is a common law incompatibility between them. Section 100. Qualifications of officers for counties and districts. No person shall be eligible to the offices mentioned in sections 97 and 99, who is not at the time of his election 24 years of age, except clerks of county and circuit courts, who shall be 21 years of age, a citizen of Kentucky, and who has not resided in the state 2 years, and 1 year next preceding his election in the county and district in which he is a candidate. No person shall be eligible to the office of Commonwealth's Attorney unless he shall have been a licensed practicing lawyer for years. No person shall be eligible to the office of County Attorney unless he shall have been a licensed practicing lawyer 2 years. No person shall be eligible to the office of Clerk unless he shall have procured from a judge of the Court of Appeals or a judge of a circuit court a certificate that he has been examined by the clerk of his court under his supervision, and that he is qualified for the office for which he is a candidate. This section increased the age of eligibility for county judges, county attorneys, sheriffs, and constables from 21 to 24 years of age. Despite complaints that judges never refused to certify the qualifications of candidates for court clerkships, the framers of the current Constitution retained the certification requirement that first appeared in the original Constitution and was continued in the second and third charters. Only a majority of the judges of the Court of Appeals could certify in the first and second constitutions. The Kentucky Supreme Court has upheld the constitutionality of a Supreme Court rule that provides that no person other than an incumbent shall be eligible to seek the office of Circuit Court Clerk without having first attained a passing grade on a standard examination administered by the Administrative Office of the Courts, in Combs v. Huff, 1993. In the opinion of the Attorney General, the certification requirement no longer applies to county clerks, and Section 100 does not require sheriffs and constables to be literate.
Section 101. Qualifications and jurisdiction of constables. Constables shall possess the same qualifications as sheriffs, and their jurisdiction shall be coextensive with the counties in which they reside. Constables now in office shall continue in office until their successors are elected and qualified. This section, as does the previous section, provides that the qualifications for constable and sheriff are the same. As was the case in the previous Constitution, each constable has jurisdiction over all of the county in which he resides. In the opinion of the Attorney General, a constable duly elected in one district may not maintain an office in another district, despite the fact that the magistrate duly elected in constable's district has not opened an office. Further, the magistrate in an adjoining district is not required to divide assignment of work equally between a duly elected constable in his district and a constable of another district. The Special Commission on Constitutional Review of 1987 recommended the deletion of Section 101. Section 102. Officers for new counties. When a new county shall be created, officers for the same, to serve until the next regular election, shall be elected or appointed in such way and at such times as the General Assembly may prescribe. This section and the statute enacted to implement it have only been applied once, as only one county has been created since the adoption and implementation of the current Constitution. In 1912, the General Assembly created McCreary County, and provided in the statute of creation that the governor should appoint county officers to hold office until the next regular election. The governor appointed J.C. Good to the office of county judge. Good resigned his office in October 1912, and the governor appointed Henry Jones as his successor. In the meanwhile, J.E. Williams procured the Republican nomination for county judge, and was duly elected in the general election in November 1912. Governor James B. McCreary refused to issue a commission to Williams, who sought a court order compelling him to do so. The Kentucky Court of Appeals ruled for Williams, reasoning that the vacancy in the office of county judge occurred in June, not October, 1912, and that therefore sections 102 and 152 compelled the governor to commission Williams, in McCreary v. Williams, 1913. The Court of Appeals also ruled that a proposed merger of the city and county governments of Lexington and Fayette County would not violate Section 102, in Pinchback v. Stevens, 1972.
Section 103. Bonds of county officers and other officers. The judges of county courts, clerks, sheriffs, surveyors, coroners, jailers, constables, and such other officers as the General Assembly may, from time to time, require, shall before they enter upon the duties of their respective offices, and as often thereafter as may be deemed proper, give such bond and security as may be prescribed by law. This section authorizes the General Assembly to require county and other officers to give a bond guaranteeing faithful performance of designated duties, and the General Assembly has done so for each such office. The Kentucky judiciary has held that a county court that did not declare a sheriff's office vacant for failure of the sheriff to execute his bond after the time for execution had expired, and had accepted a bond that was executed after the deadline, could not afterwards declare his office vacant for failure to execute the bond in a timely fashion, in Schiff v. Flans, 1896. It also ruled that a county clerk must file a bond before taking office, that filing such a bond after taking office does not comply with statutory requirements, and that, on that account, the would-be clerk may be prevented by court order from taking office, in Bowen v. Commonwealth, 1994. Section 104. Abolishment of office of assessor. Assessor may not succeed himself. The General Assembly may abolish the office of assessor and provide that the assessment of property shall be made by other officers, but it shall have power to re-establish the office of assessor and prescribe his duties. No person shall be eligible to the office of assessor 2 consecutive terms. Until 1851, the county court of each county appointed a number of tax commissioners who assessed property for taxation. The Third Constitution, in 1851, replaced these commissioners with a single county assessor who would be elected for a 4-year term and would be indefinitely eligible for re-election. By statute, the county assessor was paid by a commission of 5% of the amount of taxes collected. Some framers of the current Constitution argued that it would be less expensive and more efficient for justices of the peace to assess property for taxation, but the delegates defeated a motion to this effect. Instead, they provided that the General Assembly could abolish the office and provide that assessment be made by other officers. The framers also made the county assessor ineligible to succeed him or herself because they feared the officer would underassess in order to win favor with the voters. In 1918, the General Assembly abolished the office of county assessor, but instead of authorizing justices of the peace to assess as the framers of the current Constitution probably contemplated, the legislators created a new officer of assessment, that of county tax commissioner. In 1969, the General Assembly abolished the office of county tax commissioner and replaced it with that of property valuation administrator. In 1946, the Kentucky Court of Appeals ruled that the county tax commissioner was a state, not a county officer, and that all fees in excess of legal limits may be retained or paid into the state treasury. From Jefferson County Fiscal Court v. Traeger, 1946. The Special Commission on Constitutional Review of 1987 recommended the deletion of Section 104.
Section 105. Consolidation of offices of sheriff and jailer. The General Assembly may, at any time, consolidate the offices of jailer and sheriff in any county or counties, as it shall deem most expedient. But in the event such consolidation be made, the office of sheriff shall be retained, and the sheriff shall be required to perform the duties of jailer. The framers of the current Constitution inserted this provision as a compromise between those who wanted to abolish the office of jailer and transfer the duties of the office to the sheriff, and those who wanted to retain both offices. Although some delegates predicted that the General Assembly would soon implement this section in every county, to date only the counties of Jefferson, Louisville, and Fayette, Lexington, have consolidated offices. In 1930, the General Assembly by statute consolidated the offices in all counties, but it repealed the statute of consolidation in 1936, and the repeal was upheld by the Kentucky Court of Appeals, in Stickler v. Higgins, 1937.
Section 106. Fees of county officers, fees in counties having 75,000 population or more. The fees of county officers shall be regulated by law. In counties or cities having a population of 75,000 or more, the clerks of the respective courts thereof, except the clerk of the city court, the marshals, the sheriffs and the jailers, shall be paid out of the state treasury, by salary to be fixed by law, the salaries of said officers and of their deputies and necessary office expenses not to exceed 75% of the fees collected by said officers, respectively, and paid into the treasury. The framers of the current Constitution added this section specifically to deal with the problems of the excessive fee income of certain Jefferson County, Louisville, county officers. County officers were paid by fees, not salaries, and some of the officers of Jefferson County, the only county with a population of 75,000 or more, especially the city marshal, the jailer, the sheriff, and the county clerk, earned an estimated net annual income of at least $10,000 each from their percentage of fee collection. Some estimated the net annual income of the jailer alone to be $40,000 at a time when the governor's annual salary was $5,000. So lucrative were these offices that candidates spent thousands of dollars buying votes in order to be elected. The delegates believed that if they simply replaced the fees with salaries, county officials would have no incentive to collect fees, so they tied their salaries to the amount of fees collected. Section 246 limited the salaries of all public officers, including local officials, to $5,000 per year. The Kentucky Court of Appeals upheld a statute that required the Commissioner and Receiver of Jefferson County, which has a population of over 75,000, to send the Auditor of Public Accounts a monthly statement showing the fees and compensation collected, with the Commissioner and Receiver to be paid a salary not to exceed 75% of the amount collected or $5,000. The court also ruled that Section 106 did not prohibit the General Assembly from delegating to the county judge of counties of a certain population, 40,000 to 75,000, the duty to fix the salaries of county officials. In Stone v. Wilson, 1897. The court held that the initial legislative implementation of Section 106 was not intended to, and did not, apply to the incumbent clerk of Jefferson County Circuit Court, John S. Kane, who therefore could continue to reap the benefits of the substantial fees of his office during his current term in Norman v. Kane, 1895.
Section 107. Additional county or district offices may be created. The General Assembly may provide for the election or appointment, for a term not exceeding 4 years, of such other county or district ministerial and executive officers as may, from time to time, be necessary. This section first appeared in the Third Constitution, having been adopted without debate. Debate in the most recent Constitutional Convention concerned the desirability of the General Assembly creating the office of County Treasurer to replace the sheriff as the county's tax collector. Some counties had been empowered by the General Assembly to appoint such officers during the period of the Second and Third Constitutions, and proponents argued that these officers had collected taxes more effectively and with less expense than the sheriffs. Opponents contended that without tax collecting fees, in most counties the office of sheriff would attract few if any aspirants. The framers of the current Constitution opted to repeat the authorization for the General Assembly to create additional county officers rather than to specify what those officers might be. The General Assembly by statute requires each county fiscal court to appoint a county treasurer for a 4-year term. The Kentucky Court of Appeals has ruled that Section 107 did not prohibit a fiscal court from refusing to reappoint, solely for political reasons, a county treasurer once his term had expired in Garrard County Fiscal Court v. Layton, 1992. Many of the court decisions arising under this section concern whether or not it applies to a legislatively created office with a term longer than 4 years. The Kentucky judiciary has generally held that the section does not apply to ministerial officers appointed to hold office during good behavior, in Kerr v. City of Louisville, 1937, or at the pleasure of the appointing institution, in City of Owensboro v. Hazel, 1929. Section 108. Abolishment of Office of Commonwealth's Attorney. The General Assembly may, at any time after the expiration of 6 years from the adoption of this Constitution, abolish the office of Commonwealth's Attorney, to take effect upon the expiration of the terms of the incumbents, in which event the duties of said office shall be discharged by the county attorneys. The framers of the current Constitution added this section as a recognition of significant support among their number for a proposal that the office of Commonwealth's Attorney be abolished and that county attorneys constitute the sole prosecutors within the Commonwealth. Much anguished debate took place at the Constitutional Convention of 1890 to 1891 about how better to prosecute criminals in Kentucky. Under the system that had existed for most of the 19th century, each circuit court district had a Commonwealth's attorney, who prosecuted more serious crimes, felonies, while each county had a county attorney, who prosecuted less serious crimes, misdemeanors. Many delegates contended that the existing system allowed too many criminals to escape punishment and that by abolishing the office of Commonwealth's attorney and empowering the county attorneys to prosecute all crimes, more effective prosecution would result. In the end, the framers narrowly rejected such a proposal and voted to continue the existing system, but they did authorize the General Assembly to opt for the single prosecutor plan at any time after the expiration of 6 years from the adoption of the Constitution, an option not yet exercised by the Assembly. The Kentucky Court of Appeals has held that Section 108 empowers the General Assembly to abolish the office of Commonwealth's Attorney, but does not authorize it to legislate an incumbent officer out of office by removing his county of residence from the relevant judicial district during his term of office, in Adams v. Roberts, 1904.
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.